Hello, Chris Gant Sorensen and Perry McLennan here. Perry and I were trying to remember how long it had been since we'd been before you, and it's been a while, so we're glad to be back. Of course, all last year, I think, Perry, didn't we talk about COVID the whole time? It seems like we did.
Yeah.
So this year, we still have to talk about COVID some because there's some things you need to know, but we thought that you'd be interested in hearing a little more about the types of things employers might be anticipating with the Biden administration, in addition to our normal initial legislative update that we do at the beginning of the year. And so before we get started, though, we're going to go ahead and talk about our general stuff. But we're going to send you guys a poll, and we want you to let us know, what's on your mind. What are you most concerned about? So please complete the poll, and we'll use this to tailor our next presentations and what topics we talk about. And as always, we want to hear from you as to what you need to know, what you want to hear from us. I mean, Perry and I absolutely want to give you relevant information that you want. So even if it's not on this poll, shoot an email to Keely or to either one of us. We want to meet your needs. And as always, if you have questions, we have a Q&A platform. Perry and I try to answer those questions as we go. Some of them we cover live. Sometimes we don't have time to do all of that, but we want to try to answer as many questions as you have. And then finally, don't forget, we've got all kinds of information on our blog and on the HSB COVID resources website to help employers through COVID-19 and just generally through employment law compliance. So with that being said, looks like this is the poll result here are the poll results. So the issues that you feel you have that will have the greatest impact on your workplace in the next 4 to 6 months. 5% checked FFCRA, 3% checked the ACA, the future of the ACA, 39% checked COVID-19 vaccination plans for employees or other COVID-19 issues, 28% on the minimum wage increases, 4% on immigration, and 20% on labor relations policies and programs. All of that makes perfect sense to me. That is what I would expect. And so the good news is we'll be addressing some of that today. So, all right, let's go ahead and get started. Next slide. So Perry and I are going to just talk generally about what we see for the first initial part of our presentation, and then we'll get into some specifics. So everybody is aware that every time we have a change in presidential administration, we also have a change in who the heads of the executive agencies are. And, you certainly see policies coming down from those heads once they're installed in their position. That lean either conservative or liberal or Republican or Democrat. And so this will be no exception. There have been some replacements with the EEOC and the NLRB that have already taken place. A shift from 2 Republican NLRBs to the only Democrat one who was involved in the Obama administration. And then the EEOC, the chair of the EEOC, that has been replaced by a civil rights activist. And so no surprise there. The DOL, the EEOC, the NLRB and the IRS are the agencies that employers are more likely to note changes in employment practices. And so Perry will talk more specifically about the Department of Labor regulations that tend to vacillate every time we get a new administration in. So another thing to point out too is that presidents are increasingly acting by executive order, bypassing Congress. Well, so here's the important thing to remember. Most everything that presidents do really still have to go through Congress. So today, when we're talking about certain things, I'm going to be letting you know, is this something that the president can do through an executive order, or is it going to require Congress? And so that'll help you know how much time you have to get prepared to deal with it. Things that the president has control over with executive administrative agencies, the Department of Labor, the EOC, IRS, those are things that you'll see happening quicker. And so those are the things you'd want to alert yourself to. But some of the other things, they're not going to be able to go through until Congress can pass on them. And so that's important to keep in mind. The only way that an executive order becomes legislation is if the administrative agency charged with the mission of the executive order is able to issue a notice of proposed rulemaking and issue rules and regulations associated with the mission of the executive order. So do keep that in mind.
All right, thank you, Chris. So as Chris mentioned, employment law has really become agency law in a lot of respects, and the changing presidential administrations have a lot of say over that. The president gets to appoint the agency head when he or she becomes president, and the agency head is really the individual that will set the policy for that agency during the administration. And you can typically see how this plays out pretty quickly. Just one example, with the Department of Labor and taking wage and hour, for instance, the wage and hour division is a subset of the Department of Labor. Is the agency going to take the approach of, okay, we're going to file lawsuits against businesses and try to get judgments against them? Are we going to fine employers and make those public record to try to set an example of them? That would sort of be an example of the increased enforcement. Or are we going to increase compliance efforts? And that is usually done through issuing fact sheets about how to interpret a law, things like that would help employers come into compliance with the law instead of assessing fines against them. Sort of an example of this is back in July of 2020, the Department of Labor announced that it was not going to be seeking liquidated damages as a matter of course in back pay, wage, and hour cases. And liquidated damages is just if the Department of Labor investigates you and finds out that you owe an employee $5,000 in overtime that you didn't pay them. Typically, the Department of Labor will come in and say that you owe an additional $5,000 on top of that for what they call liquidated damages. It's an additional penalty. And in July 2020, the Department of Labor said, we're not going to do that as a matter of course. And that was sort of reflective of sort of the Trump administration and his Department of Labor sort of hands-off approach on businesses. Don't have any indication of whether that is going to stay policy, but I'm almost 100% sure that the Biden administration is not going to pursue that policy. So that's just one example. Democratic presidential administrations do tend to be more pro-labor, and Republican presidential administrations tend to be pro-management or pro-business in these employment matters. The electorate has changed a lot over the last few years, but this position is holding pretty strong. And some of you have probably already noticed this by some of the news that's come out from the Biden administration since he's been in office just over a week, I guess now. And we expect more of that. President Biden's background as a longtime Democratic U.S. Senator definitely suggests sort of pro-labor leaning and sort of the old school Democratic labor sense of the word. But he does have, a pretty big track record of sort of being a moderate. He was not, he's never been known as a super progressive politician. He has sort of moved with the times as far as the Democratic platform goes. And so it's been a big debate as sort of what type of President Biden are we going to see? Is he going to be more moderate or more progressive? And the early indications from his first week in office indicate that on the employment and labor side of things and on the civil rights side of things, there's going to be some big changes, and he's going to be pretty aggressive, and that's a few of the things that we'll talk about today. The campaign rhetoric was pretty strong in regards to worker rights. He talked a lot about gender and race disparities in pay. He talked a lot about employees' rights to organize in the workplace. He talked a lot about employment discrimination, those types of things. And these are some of the quotes that we pulled out. But if you went to President Biden's, page when he was running for office, or you go to his Twitter page or whatever, it won't take you long to see these types of quotes. If you tune into the news, it won't take you long to see one of his representatives on TV talking like this. I'm going to be the strongest labor president you've ever had, and so on. And so I think that you all as employers can expect a shift back to more of an Obama era approach to worker rights, and we'll dig into a few of those issues here. So Chris talked about executive orders, and President Biden has already been busy with executive orders. All it takes is the stroke of a pen. Sometimes they're subject to legal challenges if they exceed the president's authority to do it. But all it takes is really one of his staff members writing something up and him signing it, and it's executive order. And so he has already signed numerous executive orders since being in office, and we've highlighted a few here that may have an impact on you. He has been pretty vocal in talking about equity issues, as far as minority equity issues, gender equity issues, LGBTQ rights in the workplace, those types of things. And one of the very first things he did was repeal an executive order issued by President Trump. That was Executive Order 13950, combating race and sex stereotyping. And I don't know how many of you on or listening today are federal contractors, but this was an executive order that applied to federal contractors that concerned diversity training. And most of you have probably instituted some form of diversity training in your workplace, either through the onboarding process or some type of annual diversity training. And Trump's executive order was quite controversial. And without getting into too many of the details of it, it basically prevented federal contract employers from addressing certain things in their diversity training, like systemic racism and unconscious bias and white supremacy and those types of political issues. And there were obviously people on both sides of whether or not that was appropriate, but it was certainly confusing, I think, for a lot of federal contractors as to what that meant and what they were supposed to do with their diversity trainings. And so Biden has repealed that by executive order. So that no longer applies to your diversity trainings if you're a federal contractor. And it sort of remains to be seen whether there's going to be any additional requirements in that regard. President Biden has also signed an executive order directing all federal government agencies to review all of their existing orders, regulations, guidance, fact sheets, basically everything that they're putting out in light of the Supreme Court's decision last summer in Bostick. And that was the U.S. Supreme Court case that found that sexual orientation and gender identity are protected classes under Title VII of the Civil Rights Act under federal anti-discrimination laws. And so what President Biden is doing here is telling all the agencies, okay, you need to make sure that this is clear, that employers know this. New guidance is issued, making that clear. And I think this is going to be a big emphasis for the administration, and specifically for the EEOC. I think that you can expect an increase in discrimination complaints brought by the EEOC, in South Carolina Human Affairs Commission, which is our state version. And so that, this is a good reminder and opportunity, if you didn't take any action in response to the Supreme Court's decision, to look at your policies on this. Some of your policies, if they already prohibit sex discrimination, arguably cover this, but I'd like to see your policies really call out sexual orientation and gender identity as protected classes. I think that if you get investigated, investigators are going to want to see that language called out specifically. So think about that, and think about whether or not, you need to do any training on that, and whether or not anything else in the workplace, needs to be said to employees in regards to this new ruling. So that's a couple of things that he did right off the bat. He also, he's talking a lot about COVID-19. Obviously, that's the big crisis that he's facing, and he's directed OSHA to revisit what they're doing with COVID-19 and consider implementing temporary standards. And Chris is going to talk about that here in a few minutes. He has also issued an executive order repealing the new, the recent independent contractor guidance that the Department of Labor put out, and suggested an intent to also reverse the joint employment guidance that was put out. And I'll talk a little bit about that when we talk about the Department of Labor a little bit later in the presentation. And then finally, he's already been talking about making some changes to immigration policy, which is much broader than the workplace, but some of this does have an impact on the workplace. He has not yet, but is planning to issue executive orders surrounding making the Deferred Action for Childhood Arrivals program permanent, and establishing a means for those individuals who are in the country now, a pathway to citizenship. That obviously is going to have implications for the labor pool. And then I imagine that some of you probably hire foreign workers through the H-1B program, which is the type of visa that's available to individual highly skilled workers. President Trump, as part of his attempts to strengthen American manufacturing and buy American and all that, really limited the use of this program. And so what President Biden has proposed to do is to expand the number of visas that are eligible every year, and also to get rid of the current country quota for those visas as well. So if you're hiring foreign workers, I would definitely expect some big changes there moving forward.
All right, so OSHA, Perry touched on this. The second executive order that was handed down by President Biden was one particularly addressing OSHA's responsibility for COVID. And the overall theme was that OSHA needed to revisit all of the guidance and enforcement memorandums that it's issued and consider broadening them and addressing certain aspects of it. They gave, or the executive order gives OSHA 2 weeks to issue revised guidance for COVID-19. And I think we can anticipate, therefore, that OSHA will do so. It's interesting because those of you who have been keeping up with the OSHA COVID-19 guidance know that it was already very strict and had a number of requirements that employers implemented and then a number of enforcement memorandums that made their guidance more like requirements. That was definitely something we dealt with early. People were saying, well, it's just guidance. The OSHA COVID-19 3990 guidance is guidance, but there were about 7 or 8 enforcement memorandums that said, if you've had an outbreak and or we investigate you, we're going to look at this guidance as well as the CDC recommendations for employers and businesses to determine whether or not you've done everything you need to do to keep your workplace safe. So in essence, the 3990 guidance, we interpreted it to be like a standard. But Biden has urged OSHA to go back and revisit, and has urged OSHA specifically to think about, do you need to implement temporary standards? So I'm curious to see if they're going to turn 3990 into a standard, if they're going to add any provisions to it, with the benefit of now having some time pass and decide and seeing a number of investigations and things that they think employers can do differently. I will tell you that I've had several employers who've been investigated by both South Carolina and North Carolina Department of Labor OSHA divisions, and if they have followed the guidance, they have been exonerated. And I've seen that happen repeatedly. So that's good news. And, I think at this point, while we wait for this new guidance, I would recommend that you, number one, go back through and look at your guidance, make sure it is tracking 3990. Let Perry or I know if you need us to resend anything. Make sure it is tracking the CDC guidance for businesses and employers. And then make sure that even though it's on paper, that it's still being followed and you're doing everything you need to do and that you say you're going to do in your policy. And then obviously stay tuned to our blog. We'll let you know when the guidance comes out. The temporary standard, if there's one issued, Biden has indicated that that will need to be issued by March 15. So that's when we can expect that if it comes. It's interesting, the platform calls to double the number of investigators at OSHA. I do know from the ones I've spoken with that they're very, very busy. So this will obviously increase their ability to investigate more. I have understood that they really have not been doing in-person investigations. They've been doing quick rapid response investigations because of the sheer volume of complaints they're getting. So that is good for employers, even those who've had outbreaks. The guidance asked for emergency temporary standards for workplace safety and to reinstate the workplace safety reporting rule. Now already you're required under OSHA to record any illness that results in hospitalization. And so you're already reporting that on your Form 300. And you also have to dial it in if there's hospitalization and there is, or any death that might be a work-related COVID death. All right, next slide. So some of the dictates in the executive order were that OSHA should evaluate whether they need to broaden the protection for all workers not ordinarily covered by OSHA standards, especially public workers on the front lines. Now, OSHA has already issued first responder guidelines specific to COVID-19. They've done it with healthcare workers. They've done it with really contractors, construction workers, really about any industry you can think of. OSHA has addressed it, and then everyone else falls into the general industry. So I'm not sure how much more comprehensive we can have those there, but we'll wait and see. The other thing that I thought was interesting is that Biden said, review the enforcement efforts to identify any short, medium, long-term changes that could be made to better protect workers and ensure equity and enforcement. And at that, I think of things that they've gleaned from their investigations that they think that that employers should be doing differently. Outreach programs to alert employees of what their rights are, and they want to work on that with the Department of Labor. And then specifically work with states who don't have any state-based OSHA programs to help them implement and enforce. Next slide.
All right, thanks, Chris. I'm going to shift into talking a little bit about what we can expect to see from the Department of Labor under new leadership. The Department of Labor is really the federal agency that is probably going to have the most day-to-day impact upon your workforce. And President Biden has nominated former Boston Mayor Marty Walsh to lead the department. And he's the first union member to fill that role in nearly half of a century. And he was actually president of a local union in Boston. His father was a member of that union, and sort of he's about as old school labor union as you can get. And so what that tells us about the direction that they're going to take is that they're obviously going to be focused on workers' rights around collective, organizing and collective bargaining, which we'll talk about in a minute. But even in the non-union workplace, it really shows that they're going to be focused on additional worker protections, which I've got some examples of. The wage and hour division, one of the things they might tackle, which I know you'd be very interested in, is the salary threshold for overtime. You probably thought we might be done with that issue for a while after we went through all of that with President Obama proposing the big raise to it. And that's still something that President Biden wants to do. I don't get the sense that that's very top of their list. And so I would not expect a proposed regulation on that this year, and that would have to go through the normal regulatory process. But that's something to think about. That's in addition to the increasing the minimum wage, increasing that salary threshold for exempt workers is something they'll probably be looking at as well. One thing that President Biden campaigned on and has already made reference to is the employment status of these gig economy so-called workers. And, I don't know how many of these freelancers and consultants and contractors and, those type of workers make up your workforce. But this could be a big change. The test that President Biden is proposing to outline for gig economy workers essentially assumes that all workers that your company is compensating for work are employees. You kind of go in with that presumption that they're sort of W-2 employees, and the burden is on you to show that, no, this is a 1099 contractor. And this is the test that you would have to meet to show that they're a contractor, that the worker is free from control and direction of the employer. The worker performs outside work in the normal course of their business, and that the worker is customarily engaged in independently established business or trade. The first bullet point is just completely problematic because there's nobody, hardly even contractors, that aren't subject to some type of control or direction from you as the company that they're working for. And so what this looks like to me is really an attempt to get as many workers workplace protections as they can, allow them to sue companies for wage and hour violations, to be able to receive workers' comp and other insurance benefits and things like that. And so that's one way that they're trying to reclassify workers. The other is with revoking the Trump joint employer standard. That rule went into effect in March 2020. A federal judge struck down that rule in December, so it's been a little bit in limbo. I don't see this. It was a very pro employer interpretation of the joint employment standard. This is probably relevant for many of you. This would apply to workers that are hired through staffing agencies, leased employees, subcontractors in construction, things like that. This is the scenario when you've got a staffing agency and you're not hiring them, but they're working at your facility. And there's a wage and hour claim, or there's a discrimination claim. Can they sue you, or do they have to sue the company that actually hires them? And the Biden administration has been pretty clear that the Department of Labor is going to take the approach that they want to see as many workplace protections for employees as they can. That includes making any possible company that the employee or the worker could be subject to, including them in that. So that's a little bit worrisome. Both the joint employer and gig economy, and joint employer and independent contractor tests. I know these are really frustrating for you because these goalposts change all the time. This is kind of a classic example of agency interpretation changing with political winds and with the administration. It would be really nice if we got actually, some legislation around that or some clarity. Certainly, South Carolina courts and federal courts in the Fourth Circuit have their own tests, which is really the end all be all. But if you get a Department of Labor investigation, the person investigating is going to go by this guidance. And I think that you can expect a much more lenient standard for who is considered a W-2 employee and who is considered your joint employee with another company. So a few things for the U.S. Congress to keep your eye on. We haven't seen much in the last few years, aside from the Affordable Care Act, that really had a huge impact on workplaces. I think the one that everybody is keeping their eye on is a proposed increase in the federal minimum wage for private companies. That's not something that can happen through executive action or through agency guidance. That is something that Congress would actually have to pass a law on. I've gotten a lot of calls and emails about the minimum wage and its likelihood of success, and I really don't know. I've been skeptical that would pass through Congress, although the election results in Georgia and Democratic control of both the House and Senate has increased the likelihood that legislation like that could get passed. As of today, we still have the filibuster in the U.S. Senate, which means that the minority party in the U.S. Senate can still block a lot of legislation. There's talks about removing that, and the floodgates may open if the filibuster rule gets changed. But as of right now, I'd sort of be shocked if we see anytime soon a nationwide $15 an hour minimum wage for private companies. And I think if legislation like that got passed, you'd see some substantial changes, maybe based on geography or industry or something like that. So we'll just have to see. Paid family leave has been percolating in Congress for what seems like forever. This is a proposal that would, basically take what the FMLA does and try to offer some payment to employees that are out, on FMLA type leave, whether medical condition or childbirth or something like that. And polls show that a majority of Americans support paid family leave. And there does seem to be bipartisan support for the idea. The problem, like everything else, is how are you going to pay for it? And the Democrats want to pay for it through a payroll tax. And unsurprisingly, the Republicans don't want to do that. The Republicans want to pay for it through these other ways, like employees' ability to borrow from Social Security, things like that, but they don't want it to be an additional employer cost. They're okay with workers getting that benefit, but they're trying to think of some other funding source for it. With everything else going on, I really don't see that as something that's very likely to happen this year. Uh, the I'll hit the Paycheck Fairness Act, and I'll toss it over to Chris to talk Affordable Care Act. But the Paycheck Fairness Act is probably the one to keep on your radar if anything is going to get passed. This is the one that everyone is talking about, and essentially it's a law that would ban discriminatory pay practices with the intent to close the racial and gender pay gap that exists out there. And this was campaigned on aggressively, and so they will be pushing this legislation aggressively. It's something that President Biden, when he was a senator, was a co-sponsor of, so he's very familiar with all the positions on it. It would accomplish its goals in a few ways. One of the big ways is that it would ban salary history questions, pre-employment, because advocates say that's one way that employers sort of continue this process of exasperating the pay gap. It would place restrictions on, that's not worded well, but it would replace restrictions on companies implementing rules that prohibit employees from discussing pay. So it's not uncommon for companies to have policies prohibiting employees from discussing certain pay information, which can be problematic under the National Labor Relations Act anyway, but I see it all the time. Many companies have it. This would make clear in here that you can't do that. And it would have some pretty severe anti-retaliation and penalties for violating that. One additional thing that I'll mention quickly that's not on here is that many of you probably are required to fill out the EEO-1 annual reporting forms, and that there was a proposal during the Obama administration to include pay data by race and by sex on that reporting form, which is public information, which would be public information under this rule. And there's a lot of thought that could be brought back. That remains to be seen. I haven't seen a lot of discussion of it, but that could be brought back. That's another way that that some advocates have indicated that they could potentially close the pay gap that's out there. Those are a few things that Congress would have to do. The Affordable Care Act is another area that we could see some changes with, and I'll let Chris talk about that because she knows a little bit more than I do.
All right. So most of the changes that the Biden plan is proposing for the Affordable Care Act are going to require Congress to pass on them. But I'll cover those first. The individual mandate, as you remember, the Defense of Job and Tax Cut Acts that was passed in 2017 eliminated the penalty for the individual mandate and therefore gutted the impact of the penalty. So that was frankly a blow to employers because employers became the only individuals or the only entities that were required to abide by it, and the Affordable Care Act and the employer mandate, and that were risking penalty for failure to do so from the IRS. So that actually would be good for employers. The more people that are buying into the insurance and paying into the system, the less expensive the health insurance costs. So, but that will require Congress to act on it, and hopefully that is something that could pass. That's very important, and that benefits everyone regardless of political leaning. Premium subsidy reduction. Right now, as everybody knows, you're not required to spend more than 9.5% of your household income for purchase of health insurance through your plan, and it would be reduced to 8.5%. That's the recommendation. Also remove the 400% FPL income threshold to get a premium tax credit. Now that's interesting because if you remove that top threshold, the point is that folks who are out, who earn more income than the federal poverty level at 400% would be eligible for premium tax subsidies. And these are subsidies that they would use on the healthcare exchange to purchase health insurance with and being offset by the subsidies. And some of those subsidies that that you're eligible for as an employee or as individuals on the healthcare exchanges are pretty significant. And so that would all be in an effort to deal with the fact that some states did not adopt Medicaid or Medicare expansion. That left a gap of about 2 million people who were too poor to qualify for premium tax subsidies, but made too much money to take advantage of other benefits. And so here, presumably, that would capture those folks and permit them to purchase insurance on the exchanges. Those all require Congress to act. The one that doesn't is the employer shared responsibility enforcement under the Affordable Care Act. You know, the ESRP, which is part of the ACA, for making sure employers who have 50 or more employees are offering coverage that meets minimum value and minimum essential coverage. And so everybody's familiar with that, well familiar with that at this time. The IRS is currently issuing penalty letters, the 226J letters, for the year 2018. I have not gotten the sense that the IRS slowed its enforcement whatsoever during the Trump administration. I could be wrong, but Biden is specifically asking the IRS to step up that enforcement. So that is it overall, broadly speaking, as far as what's the most imminent approach to Affordable Care Act revitalization.
Thanks, Chris. I did get a question in the chat about the independent contractor guidance. I'm not sure how much of what I said previously you heard, but they've President Biden's revoked the Trump guidance, and we don't have new guidance. What I was discussing is what President Biden has proposed in his platform, which is a new test. And that new test looks at those three factors that I put up on the screen there. And from a big picture perspective, it's a very pro-worker test. I mean, it's basically targeted towards having Uber drivers and other freelancers like that to be classified as workers. And this has been a huge issue out in California. There's been ballot initiatives and threats of the company moving and all this kind of stuff. So, but happy to provide more information on that if you've got specific situations. I wanted to quickly touch on labor relations because, you know, this is one of those topics that is not relevant for, well, it's relevant for everybody in some sense, even non-union workplaces, but it's extraordinarily relevant for some and minimally relevant for others. But it is a big part of President Biden's platform, and he's already made big changes. He took the unprecedented step of firing the general counsel of the National Labor Relations Board, which had never happened ever. Prior to the general counsel's term ending, which was supposed to be through the fall of 2021. There's one open seat which he'll fill, and then another one expected in August of this year, in which the Democrats will, you know, democratically appointed board members will have control of the board with, and they're going to be very aggressive in returning to Obama era labor standards, which is not good for companies that are trying to remain union free. One thing that you really need to keep an eye out for is this PRO Act that is being bandied around in Congress. I don't know what the chances are of it passing. I like to, it's pretty radical. So I'd like to think that it's very low, but it's being talked about a lot, and it really strengthens union protections and has a big impact on non-union workplaces. The law would actually preempt state right to work laws, which could be devastating for states like South Carolina. South Carolina, the right to work law basically means that you can't condition somebody's employment on their membership in the union. And this is a big economic development tool in South Carolina and other states. And the law adds fines and damages for labor violations, including criminal penalties. So that's something to keep an eye on. One of the things I think they may try to do is, that applies to even non-union workplaces is in the area of employee rights, especially on social media. And so employees' ability to go on social media and talk about terms and conditions of employment and complain about pay and complain about treatment and things like that. Chris and I have to deal with a lot of situations where companies want to fire somebody for putting something inappropriate on social media, and you've got to be very careful that you don't infringe on somebody's rights under Section 7 of the National Labor Relations Act. And this National Labor Relations Board is probably going to be looking to really crack down on those instances.
All right. So I just had an interesting Affordable Care Act question from Leanna Compton, and it was, I think, specific enough, but I was answering that. But it is interesting. Go back and definitely look at your look back periods and everything that you're doing to make sure that all of your employees that are supposed to receive an offer of coverage do. So on to the American Rescue Plan, and I'm going to hit that really quickly, and I'm going to spend more time on the parts that are most pertinent to you. But overall, it's about a 19-page plan that Biden put out even before elected to fund vaccinations, offer relief to the families bearing the brunt of COVID-19, support struggling communities, and implement additional worker protections. So go ahead and hit the next slide, Brittany. The data that the federal government had at its access realized that over 20% of the earned income tax credits have gone unclaimed, that families who would be entitled to benefits have been struggling to understand the eligibility rules. Small businesses of color were not able to easily access loans. There's going to be grants and the like directed to the Black and brown small business owned communities. Less than 40% of service workers who were laid off actually received timely unemployment benefits. So folks realize that too. That was certainly in the news. And then this is particularly troubling. 47% of the children live in households that have trouble covering their usual expenses such as food, housing, and medical care. So a lot of the proposed plan is meant to address that. Next slide. Worker protections. Everybody may remember in 2008 and 2009 when we had the crisis that there were premium subsidies for COBRA during a certain time period where it was a 65%, 35% employer pay versus 35% employee pay, and then the government reimbursed the employer for the 65%. Biden is thinking about implementing that or proposing that that be implemented again for those workers who lost their health insurance coverage between March and September 2020. And this premium subsidy would go through September 31, 2021. That is going to have to be something that is passed by Congress. But presumably, most of you on this call were in business then, and so this will be easy for you to implement. You will have had experience with it before. We talked about the premium tax credit, so I'll slide on from that. Emergency funding for first responders and essential workers. So that's something that those of you on the call that are listening should keep your ear to the ground on to make sure, as usual with any federal monies, you need to apply quickly because it seems to get gone. The unemployment will increase, the payment, one of the unemployment COVID-19 payments will increase from $300 to $400 per week. And there's also a $1,400 check that he's proposing that gets sent to families. Next slide. The minimum wage increase, Perry talked about that just a little bit, but that is not imminent. That does require Congress. And even with federal contractors, Biden has asked the OMB, the Office of Management and Budget, to come up with a plan to require federal contractors to pay a $15 minimum wage, and then also to identify all federal workers who make less than that and come up with a plan and a budget for that. So that's not imminent. Short-term compensation programs, I thought this was interesting. I'm not entirely sure how this would work, but employers who are in distress would be able to keep their workers employed at reduced hours with the government subsidizing the remainder of the wages. So that'll be something interesting to keep your attention to. Next slide. COVID-19. Here are the things that I really want to spend the bulk of the time on, because if any of these come to pass, they are going to impact how employers are handling things in their workplaces. So specifically, Biden has asked the Department of Labor to provide clarification on what it means to refuse work because an employee believes there are unsafe conditions. Historically, that is an OSHA standard, and it is a significant OSHA standard where an employee can refuse to perform work if they have imminent harm or death, if they're facing imminent harm or death. And so that's pretty high, and we've talked about that before, and I won't spend too much time on that. But Biden is saying that actually the Department of Labor should issue more regulations, which they can do, that define, or not even regulations, these could just be fact sheets or guidances that define what is considered unsafe, that an employee would be permitted to refuse to work. And the definition Biden has proposed would include if the employee coming to work would not only impact the employee's health, which we already have protected under the ADA, but also if it would impact the employee's spouse's health or children's health, anyone who's living in the home with them. Family members, it would need to be family members. If they have health issues where the employee coming to work would be compromising their health issues, that is considered an unsafe work condition that the employee can refuse. That is something that, Perry and I have been getting questions on all through COVID, and up till now, that was not something that you had to be concerned about. It was only the employee's health condition. This is not enacted yet, but it is something to think about because it may come to pass. FFCRA and paid leave are the only benefits that these employees have available to them. And so this is not necessarily paid leave, and it would just be still the FFCRA leave. And we'll talk about that as well. Next slide. So Biden has proposed to enhance and extend the FFCRA. By enhance and extend, they mean that it is available to a number of employees, not just those who are employed by employers with less than 500. So Biden wants it to be available to, it's about 106 million more workers and all employers. And Biden would like for the protections for those employers under 50 to be removed, as well as the protections for those employers of healthcare workers and first responders. And as you all may remember, the Department of Labor issued its 500-page rule back in the spring for the FFCRA, and it said that employers who employ healthcare workers and first responders could refuse to give them FFCRA benefits. There were also a number of exceptions for smaller businesses that would not have to comply. So Biden proposes to remove all of those. Next slide. Biden proposes to expand the emergency paid sick leave and the emergency EFMLA 14 weeks. So this would be in addition to what has already been offered. And the reason I make that assumption is because when you look at the qualifying criteria for 14 weeks of paid sick leave and family medical leave, this is not a benefit that was part of the original FFCRA, EFMLA, and EPSL. So 14 weeks of the EPSL and family medical leave would extend to parents who have caregiving responsibilities for either children or adults due to the school being closed or the care center being closed, or due to someone being sick or from COVID. The employee themselves having to quarantine because they are sick from COVID or they've been exposed. The employee needing time off to get the vaccine. It would be a maximum paid limit benefit of $1,400 a month, and these measures Biden proposes would extend through September 30, 2021. Again, this is something that has to pass Congress, but it would be an incredible increase and broadening of the FFCRA benefits. Next slide.
All right, thanks. And we've just got a couple of minutes, so I'll be quick with this. And if you have questions, go ahead and put them in the Q&A, and we'll get to those here in a minute. Just a couple of things on South Carolina legislation. We're starting a new session in the General Assembly this month. And so a couple of things to keep an eye on there. Definitely not as much activity as with the federal government. But the big thing is really the still COVID liability bill that they tried to pass it last time and couldn't get it through, unfortunately, even though a lot of our neighbor states did. But this is a bill that would protect companies from being sued by employees or third parties because they got COVID. It would, try to make workers' comp the exclusive remedy for employees there, make that clear. And for third parties, it would provide the no liability where the company followed public health guidance. So that's back to the point about making sure that you've got a good COVID policy for the health and safety that you're following. Even without this bill, I think that, in the event that you were sued, I think a court would probably look at that. So hopeful that passes. I mean, I think that would be a really big deal if it did. So keep an eye out for that. We do have our own version of the Paycheck Fairness Act in South Carolina that's floating around there, which would do a lot of the things that the Paycheck Fairness Act seeks to do at the federal level, like ban salary history questions, provide increased remedies for employees that are subject to paid discrimination and those types of things. This is being backed by South Carolina WREN, Women's Rights and Empowerment Network, and they've been effective in getting legislation through the General Assembly before. Also, we have a version of the Paid Sick Leave Act that's also at the federal level. This one's a little different, and it's still in committee. I don't know the chances of it really going anywhere anytime soon, but it would allow employees to accrue paid sick time. For, every 30 hours they work, they accrue an hour, that type of thing. And then we've got a minimum wage bill that doesn't seem to be any appetite for, but is out there as well at the state level. And then I still get, questions about whether South Carolina is going to do anything on medical marijuana, because every November, it seems like more and more states are passing laws on this. And we do have a bill in South Carolina that's got some pretty big name support behind it. But there's also still some pretty strong opposition to it. And I was predicting a couple of years ago that it would pass, and it has not yet. So I'm not sure when that will happen, but it does not seem like that's going to be a priority this year or will happen this year. So we definitely can take any questions. Quick announcement before we do about our February webinar, which is going to be on February 25th. Same time, 12 to 1. We're always going to do them during this lunch hour. I hope that's convenient for everybody. Happy to hear feedback on that. And that whole presentation is going to be around workplace safety. Our colleague Demetrius Pyburn is going to do that. And hopefully by then we'll have some clarity on what OSHA is going to do. I mean, hopefully there's going to be new standards to talk about during that time, and new things to talk about, maybe with vaccines too. So please join us back in February. Chris, are there any questions we need to hit?
No, I think that we have handled everything, and it's great to see everybody. Hopefully you'll join us for our monthly webinars. We always like seeing a large number of participants, and are glad that we're able to provide helpful information.
Thanks, everybody.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.